So today, 9 o'clock, we're going to open a meeting of the JLCAR, and I'm going to ask Representative Leon to lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Representative. Next order of business is the seating of alternates. We're all good? We're good. Next up is review and approval of the minutes. Do I have a motion? It's been moved by Jackie, seconded by Erica, to approve the minutes as written and presented. Any further discussion on the minutes? Seeing none, all those in favor say aye.
Aye.
All those opposed say nay. The ayes have it. The minutes are approved. Moving on to the consent calendar. And entertain a motion to approve the consent calendar.
So moved.
It's been moved by Representative Leon, seconded by Representative Lynn, to approve the consent calendar as written and presented. All those in favor say aye.
Aye.
All those opposed say nay. The ayes have it, and the consent calendar is approved. And good morning, Senator Ward. Moving on to the regular calendar, first item up is Department of Environmental Services, the drinking water programs 2532. If you can come up to we'll hear from staff first, and then we'll let the agency respond.
Okay, so this proposal has one comment to discuss, and you'll find it on the bottom of page 14 of the final proposal meeting packet, which is page 9 of the roll text. So the notice for this proposal indicated that no existing requirements were being changed other than some clarifications, but the agency did delete requirements in the final proposal that were in the initial proposal. And so deleting those requirements makes the notice incorrect. One of the deleted requirements, which I believe was for the community water system provider to notify the public of a system's deficiency, that requirement has actually been moved to another rule, which is currently on our agenda in the consent agenda. That's 2025-200. The other requirement that was deleted from that section required the community water system provider to meet certain notification requirements whenever the population of consumers with limited English proficiency exceeds 20%. And so I spoke with Aaron recently, and he let me know that that requirement actually exists in another rule. So while it's been deleted here, it's been deleted because it's duplicative. But even though these requirements exist in other rules or in other places, it doesn't change the fact that the notice is technically wrong, and that it says that no changes were going to be made. So the situation can be fixed by issuing additional notice, postponing and having the agency do additional notice, or they could put the language back in the rule, or you can approve it as it is. But it's up to you what you want to do, and that's all I had on this one. Thank you.
Thank you very much. Agency's response.
Good morning, Aaron Johnson from DES. As Kim pointed out, these two notices actually do exist in other rules, or not notices, but the requirements. In addition to that, we would like to say that we did present these rules to the Water Council, as well as every regulated entity that these rules do affect were also notified of these changes. So we had the public hearing for the 720 rules, which are the ones we're speaking of. And we had an additional public hearing for the rules for specifically drinking water 803, which is on the consent agenda right now, and which are where some of those requirements moved. So while the notice said no amendments, and we understand it should maybe say minor amendments instead, we believe that the public at least did have proper notice.
Comments from the committee. Representative.
Thank you. And thank you for being here to discuss this. I recognize it sounds like you reached out to some of the more professional people involved in this, but not the public who's impacted by those notices, and who may not know where they fall because the general public isn't quite as well versed in the administrative rules as we are. My inclination would be to have another noticed hearing about those changes, because we want more people to be involved in the process and giving input. And if that initial part telling people that summary about whether or not there's significant changes isn't always correct, it's going to make it harder to make sure that the public feels heard. So that's where I'm leaning on this.
I guess I'm going to ask you a question as to either between staff or the agency can respond. So my understanding is the whole argument right now is the fact that on the initial public hearing notice, you said there were no changes. However, in the rule, there are changes. You deleted some duplicate provisions that are also still covered, but covered under a different rule. And the question is whether the notice was appropriate for what you were doing. But in the end, the actual requirement to the applicant is exactly identical. It's just, it's covered under two separate rules. Is that a fair assessment of what we just said?
Correct. There were no change to the actual requirements themselves.
And is that the staff's understanding as well, that the actual
Yes, sir.
requirements for whatever the applicant, this rule covers is still the same? It's just that it's covered not only under this, there are some in here, we deleted some from here because they're already covered somewhere else.
Yes, sir.
Okay. Representative McGuire.
Yes, thank you. In light of that fact, that the requirements have not actually changed, and the fact that at the public hearing, there were no comments at the hearing and no comments during the comment period, I would say that everyone who was affected is aware of the requirements and there shouldn't be a need to bother with a new public hearing.
Further comments or discussion? Seeing none, I entertain a motion.
Move to approve.
It's been
Second.
moved by Representative Lynn to approve 2532 and seconded by Representative McGuire. Any further discussion on this?
Thank you. With this input, I'll vote in favor of passing this. I just wanted to bring it to everyone's attention. Thank you.
All those in favor say aye.
Aye.
All those opposed say nay. The ayes have it. Thank you very much.
Thank you.
Next up is the Division of Personnel, Department of Administrative Services. We'll start with number 110.
Yes, sir. So a conditional approval request has been filed, but there are there's a few informational comments and one unclear comment to review. First, I'll review the informational comments rather quickly. The first one lets folks know that there is a definition for the term bumping because at the IP stage, there wasn't a definition. So that just lets you know that there is one now. There's another informational comment that clarifies that the request for director's review of layoff, that's not a form. So all the elements of that request is right there in the rule. So it's not a form and we didn't need to review that. Lastly, there's an informational comment about a broad exemption from 541A, which is found at RSA 21I 4215. So that broad exemption, it exempts a lot of the agency's requirements on other executive branch agencies. So it's likely that the leave request form that's mentioned there in the text is exempt from 541A because it's an interagency form. But we did check it alongside the rule text for consistency, and that was fine. The main comment to bring to your attention is on the bottom of page 11 of the conditional approval request meeting packet. When I met with the agency last week, we discussed all of the unclear comments in the proposal, and that discussion and the edits pretty much almost resolved everything. But this comment is still there because the rule's got some vague language that we're just not sure how to improve. So the rule there is about a situation in which two or more employees ask for the same day off. The appointing authority needs some discretion in determining who gets the day off. The purpose of the language is a catch-all phrase that gives that appointing authority some discretion. And they gave me an example of, like, if you have two nurses asking for the same day off, that appointing authority may need to look at some differences between the two employees to be able to make that decision. But anyway, we weren't really able to make a recommendation for language here that would be more clear or that would capture all the various, situations that could come up that a appointing authority would need to look at in order to make a decision. Anyway, that's all I had for this proposal, and I'm sure the agency can kind of answer some questions about that.
Agency, good.
Good morning, Mr. Chairman and members of the committee. My name is Matt Mavgeorge, Director of Personnel. And I want to start by thanking the staff, first and foremost, for all their hard work going into this and their engagement with our attorneys at Department of Administrative Services. From my understanding, the collaboration working relationship was pretty extraordinary. So I appreciate their efforts as well as the efforts of my colleagues here. To address the language at issue, this is really a tricky thing, as Attorney Reeve mentioned, to kind of capture. What we're trying to do is make sure that if you have two similarly situated employees that put in a request for time off, how do you deal with that if the department agency needs coverage, right? So let's say only one of those people can have that particular time period off. How do you deal with that? And so we've historically done seniority as the basis to do it. But in trying to capture that as being the determinative factor for how do you determine who gets that time off, we tried to make sure that we were, in a way, capturing all other stuff that could be out there by saying, assuming everything else is equal between these two employees, what we're looking at is how long they've been in the department, what's their seniority. And as Attorney Reeve mentioned, it's kind of hard to capture that in language other than to say, all things being equal, everything else being equal, we're going to look at seniority. And I know that the staff and the attorneys at Department of Administrative Services, as Attorney Reeve mentioned, did go back and forth to try to come up with language, and they had a real collaborative conversation. They just couldn't come up with any alternatives. So when we indicated we'd be happy to make changes to that provision if there was something better out there, and collectively we just couldn't come up with anything that fit.
The only thing I would add to that is, this is Attorney Kevin Buckley for Department of Administrative Services. This is the current language that currently exists in the rule. There were no changes made. This is the established language.
So again, the argument is we both want Monday off. I've got 10 years of service. She's got 5 years of service. I win.
Exactly.
Thank you, Mr. Chair. So just for my own clarification, this is a readoption of the rules, and this particular clause is meant to put in writing what you're doing in practice. Is that right?
Yes, this has already been part of the rules going back years, and this is how we've been applying it is at the
Okay,
agency
thank-
level is seniority rules.
Thank you.
Thank you. So, reading this, is this what would allow somebody who has only 2 years of service, but a child with a terminal diagnosis to take Christmas off, versus somebody with 10 years of service who just wants Christmas off because it's their family policy, because then things wouldn't be otherwise equal, so it's able to go outside of seniority?
Yeah, that's a great point. I think that's a great way to look at that language as far as how it could be applied by the agency. In that situation, you could make the argument that things aren't equal. We have one employee that's got a child that's terminally ill. We have another one that just wants to have some time off at the holiday. The appointing authority can look at that, or the supervisor can look at that and say, in this situation, things aren't equal. We're not just looking at seniority. We have something else to consider. So thank you for that question.
Thank you. I mean, to me, while it is ambiguous, it is the sort of thing we need while dealing with people, as far as I'm concerned. Thank you.
Any further discussion? I'd entertain a motion.
Move to approve?
Second.
It's been moved by Representative Grote, seconded by Representative Lynn to approve 25-110. Any further discussion? Seeing none, all those in favor say aye.
Aye.
All those opposed say nay. The ayes have it, and the rule is approved. Moving on to 108.
So 2025-108 are the personnel rules concerning seniority, employee performance evaluation, and compensation. This is also a readoption with amendment, and the reason it's coming through now is because it was set to expire. So these rules have not been touched in about 10 years. There was a conditional approval request filed that dealt with a majority of the comments. However, there's still a couple remaining. One is just kind of an oversight in the conditional approval request on page 5. There is a rule that says when filling out the evaluation to check the appropriate box, that language should be struck through because there is no box. There's no form for the agencies to use. These are just requirements that they have to include in the evaluation. There's no actual form. And that language was deleted in the previous section. So it just needs to be removed from the next two sections. And the next comment appears on both page 6 and 7. There are clear comments regarding the categories to be evaluated on. And it seems as though there are some arbitrary implementation of these categories. For example, on page 6, it talks about facilitation of agency functions, which includes the ability to demonstrate volunteering information and coordinating assistance to others in and outside the agency. However, that could also fall under number 2 above, which is communication. So it just seems like these are very arbitrary things to evaluate somebody on, in that they could fall under multiple categories. So when someone's filling out the form, they may mention that in communication, but as they go down, then they also have to re-include it in number 4, the facilitation of agency functions. I just think it needs a little more work in determining which category has which requirements in it. And there are a couple more examples throughout the proposal, one on page 6 and one on page 7, where there's something mentioned that could fall into multiple categories. But those are the only substantive comments I have.
Agency comments?
Yes, Attorney Kevin Buckley for DAS. The referring to the checkbox comments in both 80104 and 80105, those were, when it was removed in the previous one, we thought we'd caught them all. Those were just mistakenly left in, and those should be stricken because there is no box to check officially. And with the other comments dealing with the different categories, it's hard. It's the agency's position that there's certain things people are being evaluated on that can fall into different categories, but we try to assign it to the primary category. And the different categories of stuff to evaluate employees on is not always going to fit nicely into a single category. Sometimes there can be overlap. The important thing is to make sure that those are evaluated and are taken care of. And sometimes facilitating agency function could also fall into communication. But the point is to make sure it's evaluated and taken care of. And sometimes it can't fit neatly into one. We try to put it in the primary category that it belongs in.
Yep. Hi. Yep. My name is Joanne Leidick. I work for the Division of Personnel in the Operations and HRSU unit. And I just wanted to also let you know that we do have a template guide that guides all the agencies to write their evaluations based on the different categories. And they have been using this template for the last 10 years, and it has been successful. And we have not had any issues. And if they wanted to modify the template, they work with the Division of Personnel to put in different language. But it is based off of these categories that have been in the rules.
And these are the current rules, and none of the unions nor state agencies raised any issue with how they were worded currently.
Comments from the committee? Representative.
Thank you. Are these performance evaluations compared between different agencies, where you would look at employee A who works for this agency and employee B who works for a different, and compare their performance based on these reports?
They're based on their job functions right now on their SJD. So not across agencies, but every agency uses the same template, the same guides.
Sorry, I guess what my question is, if this is interpreted differently in different agencies, is there the potential for it to appear that everybody who works at, say, I don't even want to throw out agency A, is doing a much better job because they're much more thorough about making sure that every time something falls in, they're noting that communication and facilitating in their agency, and that it may look like agency B has employees that aren't doing as good of a job because they're doing more of a bare minimum on this evaluation. I'm looking at how a different interpretation between different agencies may end up having a negative impact on employees or the agencies funding themselves.
I don't think that would happen because the template does guide you with the same language. So under the same categories, the template says facilitate effectively communication under communication. And then under the function of the agency, it has the volunteer language. So there's no room to move it up or down. They can't move or edit the template without going through the Division of Personnel.
Thank you. I was just wondering if they would actually be filling out as much information on the various ones. To me, this is just pretty ambiguous, and I was fine with the ambiguity on the previous rule. But this one, I'm just still concerned about how it could impact people if the forms are filled out differently. And I appreciate this is your day-to-day thing, so it's a lot more clear for you than it is for people who don't do it as frequently.
Oh, no, understood. Yeah, I mean, we haven't had that situation arise since I've been here where someone was evaluated in one section from a different agency into the next. So, I haven't seen any cases of that. Just to ease
The
you.
only thing I say is English is a muddy language.
Yeah.
Right? And so things fall all over the place in the language. So, you know, what some person may define as communications, other may define as a management skill. And so I can recognize how it's hard to have a definitive list of things that only certain, you know, everything fits in an exact box.
Yeah.
And so I can recognize that. So, any further discussion?
I just would like some clarification. You keep talking about that the templates can be modified if people come to the division.
Mhm.
That is a little concerning to me because that kind of sounds like oral rulemaking. If you're using templates as a guideline and then allowing people to then change your guidelines, that means it's not being used consistently throughout the agencies. So the requirements in the rule are really what the agency should be following without any changes to those requirements. So is that what's happening, or?
It's not changing the requirements of the substance that's in the rules. It may be rearranging the way that the rule is. So maybe attendance might be second instead of communication being second on the evaluation, but the categories is still the same.
When she said that DOP has to approve it, if somebody wants to use something that's not in the template or something different, they make sure that whatever they're using follows these rules that are here and everything is hit in everything. To make sure that all these rules are applied. We're not letting anybody obfuscate any of these rules. It's hey, we want to make this here and this here. Okay, let's see what you have. Are you hitting everything that's in these rules, even if it's not in this exact order? Making sure you have all the requirements that are necessary and nothing extra.
Okay. And why would they change the order? What's the purpose of changing the order if the requirements are staying the same?
One agency has changed the order. They feel like sometimes they want to emphasize on certain things. One example was Fish and Game changed the order of the content of how it was numbered, but the content was not changed.
Okay, thank you.
Any further discussion? So my understanding is you're willing to strike the two places where we have the checkbox issue,
Yes.
and then you want the rest of the rule to be passed as is.
Yes, sir.
Okay, so I entertain a conditional approval that states that. If some,
So, second.
it's been moved by Senator Rin as a conditional approval, striking in page 6 and 7, the checkbox language, and then approving the rest of the rule as written. And it's been seconded by Representative Lynn. Any further discussion?
Thank you. I recognize that this is an ambiguous area. Just noting that there potentially could be more time to do this before the deadline. I'm still not entirely comfortable moving forward on something that could be implemented differently for different employees.
That being said, all those in favor of conditional approval, say aye.
Aye.
All those opposed, say nay.
Nay.
The ayes have it, and you have your conditional approval. Moving on to number 109, investigations, 25109.
This set of rules has to do with, yes, investigations, discipline, non-disciplinary communications, and non-disciplinary removal. It is another readoption with amendment because the rules were set to expire. And there was a conditional approval request filed that addressed the majority of the comments. However, there's still two unclear comments. The first appears on page 12 of the conditional approval request, and that has to do with the rule that states revocation or suspension of a license or certification or other form of permission could result in termination for cause. In the conditional approval request, in the section to do with disciplinary suspension without pay, they included the language that the loss or suspension of the license would be for 30 days or less. So there's just a suggestion in the termination for cause section to include if the license or certification is lost or revoked for more than 30 days, just to make that clearer and make sure there's a distinction between the two sections. The next one is on page 13. This is also under the termination for cause section. There's an unclear comment because the language used for an offense to terminate an employee is the exact same language that's used in the written warning section and the suspension without pay section. This has to do with sexual harassment. And due to the language being exactly the same, the enforcement of this rule could be arbitrary without any examples or additional criteria for agencies to follow in determining whether an offense would reach the level of termination as opposed to suspension without pay. So it seems as though something could be added to that particular section, maybe talking about repetition or severity to somehow make it different than the other sections so that agencies have an easier time determining what conduct would result in termination and which conduct would result in suspension without pay. And this is important not only for the initial discipline, but also when it goes up on appeal, because this is the same set of rules that the Personnel Appeal Board would be considering when determining if the conduct taken was reasonable. Those are the only comments I have.
Agency comments?
Yes, in reference to the first comment on 1,308B2, the agency we attempted to correct this language between the final proposal and the conditional, and the agency has no problem adding the suggested language on the conditional or suspension that will last more than 30 days. We have no problem adding that to just make that more clear compared to the other one as far as that goes.
And as far as Personnel Rule 1003.08B24 regarding the sexual harassment, we think it's important to keep it as is. And the reason why is the criteria that was talked about just now about potentially adding already exists in a rule in the same section. It's in Personnel Rule 1003.03, and it's called determining the appropriate form of discipline. And it goes on to state that in determining the appropriate form of discipline under Personnel Rule 1002.04 through .08, the appointing authority must consider factors including but not limited to the impact the conduct or offense has on the operations or functions of the agency, the nature and severity of the conduct or offense in relation to the employee's position, classification, responsibilities, and accountabilities, and the functions of the agency, and the employee's past record of performance and discipline, including whether or not the employee has been disciplined in the past for the same or similar offense. And so that particular rule gives the appointing authority the guidelines it needs, the criteria, if you will, to assess whether or not this particular type of conduct falls into a category that should result in a letter warning, a suspension without pay, or termination. So a lot of it's going to depend on the severity of the conduct. And a lot of it might depend on whether or not this is the first time this similar conduct has happened by this employee. Have they already been disciplined in the past for similar conduct and maybe got a letter of warning? Now the appointing authority is going to look at it. It's happened again. We're going to bump this up to a suspension without pay, potentially termination. And it's not a one-size-fits-all type of thing when you talk about the breadth of sexual harassment. There's different types of things as the rule itself talks about verbal, nonverbal, physical conduct. It could be touching somebody's shoulder. It's different types of conduct that's going to fall into that, and it's not neatly defined where you can say this type of conduct will automatically result in a dismissal versus a suspension without pay. There has to be that built-in flexibility for the agencies to be able to navigate what's the appropriate form of discipline.
This is the current language that currently exists, and where sexual harassment is such a fact-based offense, it would be, I think, extremely difficult to come up with language that addresses every possible scenario and properly puts it into the right level of discipline category without giving the appointing authority the discretion to take the totality of the facts into account to make a proper determination based on the actual incident that occurred.
Discussion. So it sounds like, excuse me. So it'd be a conditional approval request is what we'd be looking for. You've agreed to the language as recommended by staff to be added to the rule. And the rest of the rule you'd like to pass as is.
Thank you. I do have one question. I was very concerned by the inclusion of the nonverbal, what I take as nonverbal and non-physical conduct, and that being able to be a fireable offense. If somebody were to go like this and look people up and down once, is that a fireable offense, or would that require the repetition where that just becomes a huge problem, where the nonverbal, non-touching type of action could actually lead to somebody being fired and losing their retirement?
Again, it's tough to say with it being so fact specific. You have to look at the different criteria as far as that other rule to sort of figure out the appointing authority has to have that discretion to look at it and determine what is this conduct. Does it fall into something that's going to constitute sexual harassment? And it's important to remember we do have a sexual harassment policy that came as a result of executive order. So that's what they're going to be looking at to determine whether or not there was a violation of that policy and how that fits out and how is that conduct defined in the policy to rise to the level of constituting sexual harassment. So it's so case specific. It's hard to say if one particular example with like the looking up and down is going to rise to the level of the terminable offense. And it might have everything to do with what's the prior history of this particular employee who's accused of the conduct. Have they engaged in similar sexual harassment in the past, or even other types of sexual harassment in the past, that this thing might be what puts it over the edge and say, you know, this is enough. We need to terminate this employee based on this conduct. Where another employee, it might be the first time that something like this happened. And it's the like you said, the looking up and down, and maybe that results in a letter warning.
I just hope those sorts of more passive things aren't a cause for firing unless it's a pattern of very egregious behavior.
Understood.
Any further comments from the committee? I'd entertain a conditional approval.
Move to approve.
It's been moved, seconded by Senator Reardon. Any further discussion for a conditional approval that will add the language in that the staff recommended and approve the rest of the bill? All those in favor say aye.
Aye.
All those opposed say nay. The ayes have it, and the rule is approved, conditionally approved. Next up is, actually, I'm going to skip over and go to the Department of Health and Human Services, and we'll come back because we know we're going to have a bigger discussion on the DNCR. So if we could have Health and Human Services come up for Rule 2516.
So this is an interim rule. It is HEC 6420, and it describes the mechanism used by the department to implement requirements for residential treatment programs. It's basically reimbursement for covered services under Medicaid. There are actually no issues with the rule text. The problem is the rule cites to requirements in HEC 6355 regarding certification for payment of foster care programs. This was also an interim rule, but it expired in September of this year. So this interim rule that we're reviewing is citing to an interim rule that is expired. So there are no requirements there. And so the question is just, it's unclear how the agency would implement these rules if the other ones are expired.
Agency's response.
Good morning, Nicole Valenzola for Department of Health and Human Services. HEC 6355 did expire in September. We are working on it right now to re-implement it. The department has been continuing to still provide payment to those programs and sort of in business as usual. 6420, which is the interim rule today, does point to 6355, but it also points to another large rule, 6350. So it is pretty important that the rule do get passed because it also impacts residential treatment programs and res programs. And 6355 is foster care through agencies.
Comments from the committee, although I'm pretty sure the comments are going to be like, you had an interim rule, why didn't you finish rulemaking on that interim rule, which now you're relying on a rule that's expired, which is problematic. And,
yes, it's
and
multiple bureaus. Yes, impact.
But they also sit there and state right now, this is really important. So I think all of those things are in conflict with each other, and probably the legislators in the room aren't happy about that.
Mm-hmm.
Representative.
Since you've encapsulated my comments on that issue very thoroughly. I appreciate it. I do have a separate comment or concern. They're looking at the definitions and reading the rule. There are a great number of places where you're citing federal rules without a version or a date, and I'm concerned about that. How do you ensure that the version that is enforced is the one that has been approved by this body?
The federal citation would be the most current federal citation. So
That's unconstitutional.
I would have to do some more research on that.
Well, okay, my point is that the state constitution clearly says that we're only liable to laws that have been approved by the people or their elected representatives. So if Congress passed a law, great, but if a federal department issues a rule, that's not a law and it hasn't been approved by an elected representative unless we approve it here. And
I guess I have a little bit different take. I mean, it seems to me that the question would be, is the rule properly authorized under the federal statute? If it is, then the supremacy clause comes into play and the rule applies.
Yeah, these are Medicaid's covered services that the rule is dealing with.
I guess what I would say is, without knowing the specifics, it's hard to. But as a general proposition, the federal government is authorized to enact rules just like the states are, and if the federal rule is proper, and, whether it is or not, I guess would be something to be decided in federal court probably. But assuming that the federal rule is proper, I think that it applies under the supremacy clause.
well, it's a concern of mine. And I know that the federal agencies have a less controlled process. I mean, Congress doesn't control their rulemaking as tightly as we control our agencies. And therefore, the possibility of a rule that is beyond the scope of the law, although in the same general area or whatever, is, in my opinion, rather high. So I'm concerned about this.
So, Representative Ladd.
Thank you, and I share those concerns. It's not just about what stands at the federal level, but what the state is doing to enforce federal regulation that hasn't been specifically approved by the legislature. That's why in so many cases it states the CFR as of the state. And so by doing that, any changes need that approval. And additionally, I had one other point of concern. If our Medicaid error rate is over a certain level at the end of next year, we're going to receive much lower payments from the federal government. If the rule that was in process and again will be in process isn't approved and passed by then, are we at risk of having too high of an error rate and receiving a lower match on our federal funds?
1 second, I want to let them respond.
I would have to look into that. The rule that is expired now is how the programs are certified and quality, et cetera. Department still is certifying and still is, if applications are coming in, they're still moving forward. So we would have to see, it's 6420 if that didn't go through. We could also look into what that would mean from a dollar rate.
Thank you.
But I unfortunately can't personally answer that in this moment.
So as long as you can make sure that that's not going to increase our error rates and it's done, that would be helpful. I know it's probably just raising a concern you haven't seen, but I'd just like to make sure that there's eyes on that.
Mr. Chair.
1 second, Jack.
Well, I just want to make note that we have federal regulations and rules in most of our rules. We've not had this discussion before, so I don't really think that. I just want to make sure we're not being persnickety about one thing in one area, whereas we haven't applied this concern in other rules.
I'm sorry.
On a totally different issue. I'm not sure I understood what you said about your expired rule. You are still proceeding as though it were in effect?
Correct. It is a benefit to the agency foster care programs that we continue to review those programs and issue the funds.
Is that possible?
Representative Lynn?
No, I was going to say, I think, I mean, it seems to me it would be, I would have a hard time understanding how it would be workable for us to, in other words, if there's a specific, it would seem to me that if there's a specific rule that the federal government has adopted pursuant to some federal statute that we think goes beyond the authority of the federal government to do that, or the rule is, then I think that there are procedures under federal law for challenging that. But my problem is if nobody has done that, or if they've done that and lost, it seems to me it would be awfully hard for us to do anything other than say presumptively this rule that the federal government has adopted is valid because nobody has challenged it and nobody. I mean, I would think that would be normally the way in any area that we would adopt state rules. If it turns out that the federal, somebody does challenge it after we've adopted the rule and it's a successful challenge, then maybe we have to do something to change our rule at that point. But I mean, it would be, how are we gonna make rule? How are we gonna decide whether this federal rule is proper versus that one? It's awfully hard to see how we do that in this context.
So other question for you, Doug. So, number one, I'm not sure we want to say no to this rule because I don't think we want to stop paying our foster care families for the services they're providing to the state. So I think that's problematic, number one, in and of itself, that we're stuck with an interim rule instead of a regular rulemaking process and not having that happen. My question revolves around the expired rule. Would they, due to the financial nature of that bill, be able to bring an emergency rule forward next month? But because it was an interim rule, can you make that an expired rule? I think the answer is no, but I'm not positive.
Well, I think the concern here is, right, we have two different rules. So if this rule to be approved, and now they're referencing, so the emergency rule would be on the other side. And if the argument is risk to public health and safety or a financial impact, a substantial financial impact, there could potentially be grounds for an emergency rule. So if I were working this out, I would say it is possible that you could approve the rule and then the agency could follow up with an emergency rule.
And then they wouldn't be referencing an expired rule because they'd have an
Correct.
emergency rule in place.
Correct, but they would still have that limitation. But again, right, this is without having all the facts.
Right, exactly.
I'm just saying
I'm
it
just
is
trying to,
something.
I wanted to see if emergency rules was a possibility. My inclination was, based on the financial aspect of it and health and public
If the-
safety aspect of it, it would be allowed to, so you'd have a valid rule that you're referencing here by the end of next month.
I could see the potential existing, the possibility existing, yes.
Senator, I don't think you need to worry about that because the agency has already testified that they are implementing the expired rule already and paying people. So I can't imagine they'd stop doing it.
Well, I tend to agree with you, but I'm also trying to address Representative Leon's comment of they're referencing a fee-based rule that potentially Medicaid could say, well, you don't have rules, so we're not going to pay you, and now we have a different issue. So I'm trying to alleviate that problem as well by having at least an emergency rule in place for fees. So we don't have that potential problem. If it maybe turns into a problem, I don't know if it will or won't, but I'm just trying to walk it through in my head. So that being said, this is an interim rule, meaning you're going to be entering regular rulemaking as well.
Yes, and we've already started drafting. We're ready to go. We're just doing this to avoid expiration right now.
And this is a conditional approval.
I'm sorry?
This is a conditional approval.
A conditional approval, yeah. Do I have a motion?
Second,
Moved by Representative, Second Grow to do a conditional approval with the understanding you might consider bringing an emergency rule for the fees that you're referencing in here. So those are covered until you finish real rulemaking on the fees. So all those in favor of conditional approval, say aye.
Aye.
All those opposed, say nay. The ayes have it, and you have your conditional approval, and please consider filing right away the emergency rule so we can.
Sure. Thank you so much.
Next up is Department of Natural and Cultural Resources, 25-169. Agency
Okay.
comments.
Yeah, so as you probably recall, this proposal was postponed from last month's meeting after a robust discussion during that meeting. This Monday, we sent out an email to the committee. It was the director's memorandum that outlines why we think the agency is acting within its authority to implement the prohibition on burning brush larger than 5 inches in diameter, and that 5-inch limitation isn't arbitrary because it is selected to comply with the existing air standards, air pollution standards. An amended conditional approval request was filed, and we don't have any substantive comments on it. I should point out to you in that amended conditional approval request that that in the sections on the issuance of permits, that 5-inch diameter prohibition has been removed, and it's been moved over to the permit restrictions section. You'll see those changes on 19 through 21 of the amended conditional approval packet. So basically, that restriction isn't a condition upon issuing permits, but rather it's a restriction on the permittees. So moving it over to that section makes sense, we think. But anyway, that's a summary of the issues, and I'll turn it over.
Any further comment by the agency?
No further comment. Steve Sherman, I'm the Chief of the Forest Protection Bureau. Thank you, Senator.
Okay. Comments from the committee.
Thank you, Mr. Chairman. In the time since the last JLCAR meeting, I've looked a lot more closely into all of this background, including the environmental rules. The environmental rules are based upon the idea that if wet wood that's over 5 inches in diameter is burned, it has an opportunity to smolder and cause pollution hazards. That combined with the other concerns around the 5-inch wood being an issue about how quickly it would be extinguished, if it would present risks, are all downstream of other decisions. 5-inch wood that is dry and is appropriate for burning itself is not a categorical risk. It's not an increase to environmental concerns unless it is wet and smolders. And therefore, I can't support, I appreciate what you did in order to change this and move it around within there so that it's not one of the conditions of the permit. But I can't support something that makes it, I can't support a rule that says that because sometimes something's a problem, it must always not be permitted.
Further comments from the committee? Representative McGuire.
Yes, thank you. I'm concerned about how this rule would be enforced. Is that 5 inches a maximum diameter, a minimum, average? Is it at one point on your piece of brush or over the entire length? Who measures it? What's the tolerance?
So the 5-inch diameter is the maximum. Wood can't be any greater than 5 inches. As far as enforcement, it's written on the permit that the permittee signs, so it's very clear there that they can't burn anything over 5 inches diameter. During inspections, that is looked at, and if there is wood greater than 5 inches in diameter, they're advised that they have to remove that wood in order to obtain their permit. If it's online, the permittee certifies that they don't have any wood or they won't burn anything over 5 inches in diameter. So that's the enforcement end. If it's, and that's diameter regardless of the length of wood. So it can't be 5 inches on this end and 8 inches on the other end. It is the maximum diameter.
My question was, if you've got a 3 or 4 inch piece of brush, and at one point it's got a merger and it's like 6 inches around at that one point. Is that invalid? I mean, your definition assumes that you're dealing with a cylinder, and my experience with brushes is that they're not usually that way.
Correct. I would agree. It's not a uniform thing all the time. You could have different variances to it. We, on our enforcement end, between my staff, the forest rangers, as well as the appointed forest fire wardens, we do use common sense when we're out there. If there is one little bit that extends out larger, we're not going to give somebody a summons or make them put their fire out. But this is an overall prohibition on burning over 5 inches. We're not going to chase down little variances.
How do you measure 5 inches?
How do we measure that? I mean, you can measure it, once you do it a lot, you know what 5 inches is, but if I was to talk to the general public about the 5-inch diameter, they can measure that with a ruler. And, you know.
At the end of a piece of brush, they can use a ruler. What if there's a swelling in the middle? I mean, you can't measure that with a ruler. So basically it's eyeball?
But no, I mean, the 5-inch, I'm not saying we go out with calipers and measure every bit of it, but when you're looking at a pile of brush that somebody is going to burn, if you're looking at consistency, and if there is some variance of a minor degree, that is not going to get caught.
I have two questions. First question is, am I understanding correctly that if you are somebody you're planning to burn some wood and you've got a piece that's over 5 inches in diameter, you can cure the problem by splitting? Is that right? Making it into smaller pieces?
You could split it. And if you look up even firewood, once you get up over 5-6 inches, you run into fuel moisture issues where the fuel moisture it doesn't release that fuel moisture as quick. This is why people cure even 5-inch firewood for months at a time before burning it. Otherwise, it's considered green wood. So yes, you could split it and get it down to that size. So if you had a 10-inch piece of wood, you could split that down to 5 inches and burn that.
The other question I have is, could you just, I read the letter that you provided, but I'm just curious. Could you just tell us, is this the 5-inch sort of rule, for lack of a better term? Is this something that is in place in regulations in other states around the country? I mean, are we unique in this regard, or is this something that, other states have similar regulations?
Specific to the 5 inches, I'm not sure on that. When you look at outdoor burning, it's all over the place on regulations. Some states regulate how high the flame length can be. So I don't have an answer to that as far as what all the other states are doing.
Thank you.
Thank you. Again, bringing up the fuel moisture, sometimes wood that's over a 5-inch diameter could have the higher fuel moisture, but there's also the potential for dry wood that does not burn, that is not negatively impacted by being 5 inches. Is there any process in the state in order that would allow somebody, whether it's somebody with a significant amount of woodlands or something else, or a bonfire or something of that sort, to burn wood that's greater than 5 inches in diameter through any other process?
There is not any other process. 5 inches is the maximum.
So as a clarification, because of the rules that we are adopting now and the environmental rules that are currently in place, those are the limitations on burning any wood greater than 5 inches in diameter in the state of New Hampshire, and it's not otherwise authorized by statute or any other guideline, any other past.
Correct. And looking at looking at it and talking with DES, this goes back to the 1970s, and that has been how it is. And we still feel it's applicable due to the wildfire dangers and just looking at a rule that can be applied statewide for the common citizen to implement in their backyard without a lot of confusion.
And then one more question. Then my understanding would be that the only ways to change that and permit, either in certain cases or more widespread, for people to burn over 5 inches in diameter would either be to change the statutes to specifically permit that, or if somebody were to be charged with it, to deal with that through the judicial process.
I mean, if there was a statute that said that, then that would obviously change our rulemaking. So yeah, I guess the answer is yes. Again, looking back at why we have these rules, it is for that wildfire protection and rules that people can understand. And whether this is 5 inches, 10 inches, 20 inches, at some point, people have to measure the wood. There has to be a restriction at some point. And, you know, the 5-inch is a number that is easily identified, and it allows for that fuel moisture to not become a problem, to not allow fires to smolder. It reduces smoke or nuisance smoke complaints. So there's multiple aspects to this that come into play, but that's those I would understand to be the ways that it could be changed.
Thank you.
Representative Lynn?
One more. Okay. Sorry. And then I just had a clarifying question for the attorneys. The way that we interpret readopting our rules is that basically, if it ain't broke, don't fix it. So unless there's an outside input on the administrative rules, when they come up for readoption, we go with the history of how they've been implemented in the past and assume that that's the baseline moving forward, or is that a wrong interpretation?
I don't think you necessarily need to do that, right? If we have missed an objection in the past, it doesn't mean we can't bring it forward now.
Okay.
So you could look to the rule being in place since 1979 for guidance, but it's not necessarily binding.
Okay. Thank you.
Representative Lynn?
Yeah, I'm sorry, one just final question I have is as this rule's been in effect for a while, as I understand it. I mean, can you tell us, has this been the subject of controversy before? I mean, is there sort of a cadre of people who have said this is why are you doing this? 5 inches doesn't make any sense. It's really negatively impacting my camping experience or my management of my land, that kind of, have there been complaints about this?
I've been with the division since 1997. I've been doing wildland fire that entire time. I've never heard anybody come up with a complaint against the 5-inch diameter. This is the first time that I've had to talk to it.
Representative McGuire?
Yes, my concern remains, how do you enforce this? Do you inspect fires, bonfires?
So each forest fire warden has the authority within their towns to issue fire permits. And they do, under that authority, they can inspect fires. As I stated the last time, and kind of the reason we did make some changes here, are 100% of those checked in person? No. But they are discussed with the permittee that they can't burn over 5 inches. So there is some degree, just like speed limits or anything, people have to understand these laws, these rules exist to abide by. When we do inspections, our forest rangers also do spot inspections. We are checking for that. And if somebody is burning non-permissible material, then we educate them further. It's the same as somebody burning without a permit. Does it happen? Yes, it does happen. And we educate people and explain to them what the rules and the laws are. And usually that takes care of the problem.
Great. So I'm going to make a couple comments. So it's my understanding, Chief, that the law, well, maybe my first question is for Doug. The law that allows them to regulate this doesn't have a specification in it for 5-inch, 10-inch, 2 inches, nothing. It just says you're required to regulate this and manage. Is that accurate?
Correct.
And and again, for us, the definition is what exceeds authority of the law for an objection, whether or not their definition of regulation exceeds the authority, but the authority doesn't put any stipulations in. Is that my understanding?
Correct.
Okay. So, Chief, to you, the question is, because you have the obligation to regulate, you use two basic standards for the regulation. One was wildfire protection, right, to make sure we don't have all the forests burned down in New Hampshire like California. And then the second part was air quality, right? How does the fire deal with quality of life for everybody else in the world? Is that my understanding, how you came to the 5-inch using the DES rule of a definition for air quality?
The DES rule exists, the 5-inch, so we don't contradict that. And it aligns with the wildfire prevention. So you have those two aspects that actually come into alignment for the 5-inch rule.
Great. And lastly, when it comes to enforcement, I'm anticipating most of your enforcement is complaint-based, where the neighbor says his smoke fire pit's blowing into my yard. Can you go talk to him about it? And the fire warden would show up. And if I had 10-inch logs in mine, I'd be cited for, if I had a permit, I'd be cited for violating the rule, or I'd have at least have a stern talking to for violating the rule. Is that accurate?
Our enforcement starts at the lowest level with education, and that's the permit process. So we start there, and then we do get complaints. So we do follow up with those and enforce it that way. Also during routine patrols when we see smoke, and through the forest fire wardens who are doing inspections.
Thank you. I would like to make the point that in the statutory authority to set the guidelines, that's for camp and cooking fires, which have been interpreted as category 1 and 2. That's why I believe that this limitation on category 3 and 4 fires is beyond statutory authority, and that's my reason for objection.
Any further discussion? I'm going to move to approve 169, and I just asked the chief that in future, when you're looking at this rule, is to deal with how do citizens burn 5-inch wood, bigger than 5-inch wood? Should they, or are there conditions under which that might be allowed? So, but my motion is to approve.
I'll second.
Any further discussion?
I'm going to vote against it because this rule is unable to be enforced in a fair and non-personal manner. You've got undefined rulemaking all over the place on how the rules are enforced and what the criteria are for whatever punishments there are. And just shouldn't happen.
Further discussion? Seeing none, all those in favor say aye.
Aye.
All those opposed say nay.
Nay.
The ayes have it, and the rule is approved. Next up is other business. In front of you, you have the tentative JLCAR meeting dates. I'd entertain a motion to approve the meeting dates. One thing I'll notice is the meetings are staying in this room, so we'll continue to meet here. For the next year anyway.
I'll move to approve the meeting dates.
It's been moved by Representative Liv, seconded by Representative Leon to approve the meeting dates as presented. Any further discussion? All those in favor say aye.
Aye.
All those opposed say nay. Ayes have it. The meeting dates are set. Is there any other business to come before the committee? Seeing none, we are adjourned.
Cancel the.
Hold on, apologize.
The last time you do that.
Yeah, the last time we have to do that. There's been a motion
Mr.
to cancel.
Chair, I'd like to suggest that on these tentative dates mentioned that the continued meeting is only held when specifically authorized and not as a normal rule, because we haven't needed a continued meeting in several years.
So if you look at the approval that we approved, that says if a continuing meeting necessarily be scheduled by the call of the chair.
I think that would be a better way to do it than to have to cancel it every meeting.
Correct. All right, one more time. Sorry, let's do that again, just because we had some, is there any other business to come? We have a vote. We have to vote on the cancellation, right? So all those in favor of canceling the continued meeting, say aye.
Aye.
All those opposed, say no. The ayes have it. Continued meeting is canceled. And we see you guys next month.